6 New York State correctional officers were indicted on murder charges, yet their bail was unusually low. I wonder why. Hey, what's up, guys? Long Island Audit here, back again with another video. Thank you all for joining me for this live stream. Earlier today, I posted the video of the arraignments. I was there during the arraignments of the New York State correctional officers who were indicted on murder charges of Robert Brooks. I wanted to bring in my attorney and former prosecutor, Jacob Uriel, to discuss this case, and we're going to go over it and break it down and take your questions. So let us know in the chat what's up, what sort of questions you have. Jacob, thank you for joining me. As always, my friend, it's really good to see you.
Pleasure, Sean.
So we're talking about the Robert Brooks murder from the New York State Correctional Facility officers. That was gruesome. It was on video. I was there in Oneida County in the courtroom in the jury box recording the proceedings as well as the press conference. So we're going to take a look at that video. And a bunch of people had questions in the comments in the earlier video that I did this morning. So I just wanted to bring and get your thoughts, Jacob. So
sure,
let's get right into it.
Hands alone.
Just let me know if you want me to stop it or pause it.
I haven't seen this before, so.
You can come right up to the podium, sir. This is the matter of the people against Nicholas Anzalone, Indictment 25035, on for arraignment today. Defense counsel, would please note your appearance for the record.
Good afternoon, Your Honor. Andrew Safranco of Lamar Safranco Law.
Do I understand correctly, Mr. Safranco, you've been retained to represent Nicholas Anzalone?
Yes, Your Honor.
That is your name, sir, Nicholas Anzalone?
Yes.
How old are you, Mr. Anzalone?
44.
Mr. Anzalone, you're here today because the grand jury of Oneida County returned an indictment against you, and you have to be arraigned upon that. Counsel, you may arraign.
Thank you, Your Honor. Mr. Anzalone, in indictment 2025-35, you have been charged by an Oneida County grand jury with various crimes, the top count of which is murder in the second degree. And I'd ask Mr. Safranco if you waive further reading.
I do, Your Honor. Ask you to enter not guilty, please, on behalf of Mr. Anzalone.
So just really quick, I'll pause it right here, Jacob, because I wanted to bring this up really quickly. When we spoke about this off camera, you had brought up, we were talking about the murder in the second degree charge, and you had brought up that it was, you had looked it up, the indictment, and you brought up that it was depraved. I'm going to pull up something right here so we can read. Can you explain to the audience what the subsection for depraved is?
Sure. So, in a nutshell, New York State has a bunch of different subsections for the Murder 2 law. This particular one is being charged as depraved indifference, which means they're not being charged with intentionally trying to kill somebody, but they're being charged with doing something that's so depraved that it's equivalent essentially to intending to try to kill somebody. And when we talk about so depraved, New York law has some pretty harsh words, right? Depraved indifference to human life, and this is kind of, I'm reading from kind of like the third of the way down. Depraved indifference to human life reflects a wicked, evil, or inhuman state of mind as manifested by brutal, heinous, and despicable acts. It's evinced by conduct that is wanton, deficient in a moral sense of concern, devoid of regard for the life or lives of others, and so blameworthy as to justify, and it goes on, so blameworthy to justify essentially criminal liability that's equivalent to an intentional homicide. So these are, this is a really strong condemnation in terms of this charge by the DA, because realistically, it's very hard to show somebody's intent, especially in a case like this, where it's hard to show that you're intentionally trying to kill somebody. I know a lot of people are going to say, well, obviously, who would do all that stuff? But, we'll get into this more of it later. But it's not that obvious, especially when you're talking about legal burdens and stuff. But this is basically the prosecutor saying, this is really, really bad. Like, even though we can't prove you intended to kill this person, your behavior is so wanton, so evil, that it still rises to the level of a murder. And that's a hard bar to get to.
Right. And, when you first pointed these jury instructions out to me, and I saw wicked, evil, or inhumane state of mind as manifested by brutal, heinous, and despicable acts, I immediately was like, well, yeah, it makes sense, because when I watched the video footage of Robert Brooks being brutally tortured and eventually murdered, I didn't, they were smiling. It's all of the video in context, just to me, really is the definition of what this depraved indifference charge is. So let's just get back to the video. We'll
Sure.
talk about bail.
Very good. A not guilty plea is then entered on the defendant's behalf. It would be my intention at this time, Mr. Sifranco, to adjourn the matter to this point toward the end of March. I'd like to give you some time to review the discovery materials that I imagine have been or will be supplied to you shortly, and then have a pretrial conference to discuss scheduling of motions and things of that nature. March 31st, 9:30 a.m.
I'll be
Judge,
there.
at this time, I'm going to hand Mr. Sifranco a copy of the indictment. One name is redacted from the indictment because that individual is not yet in custody. I am also handing him over standard pretrial notices. Judge, I've included an ID notice, even though there were no formal identification procedures here. The ID notice is self-explanatory. It has to do with people who testified in front of the grand jury that viewed videotape of this assault and indicated that this person is such and such. I don't know that it will be the subject of the hearing or not, but I'll let Mr. Sifranco take care of that.
Can you explain that part or no?
I do acknowledge it, Your Honor. Thank you.
I'm sorry?
Do you want me to explain what just
Yes,
happened?
please.
All right. So they're talking about ID notice. New York State CPL 71031B deals with the government's responsibility that if there's an identification made to the police or to the government by a third party or a witness, then they have to notify the defense of that within 15 days of the arraignment, or they can't use it. So the government's just talking about that. That's what they're talking about, the ID notice.
Okay, perfect.
Thank you. All right, and with that, if I understand, I want to be heard on the question of bail. Mr. Fitzpatrick.
Your Honor, due to the serious nature of the charges, our recommendation would be $50,000 cash or $250,000 bond or partially secured bond.
Oh, okay. Mr. Fitzpatrick, I'm having some difficulty hearing you. I'm going to ask you if you use the podium that has a microphone available to you. We'll get that over closer. Mr. Sifranco, did you want to be heard on that topic?
Yes, Your Honor. We were joined in that request by the district attorney. We're prepared to meet the $250,000 bail bond. My client is a lifelong resident of this county, has voluntarily surrendered himself, as all of his family in this area known about these charges, could be possibly coming for over 2 months. Availed themselves, have been in constant contact with my office. He does not have a valid passport, but he has surrendered that not valid passport to my office. He has no intentions of fleeing the jurisdiction, has all intentions of being in court every time it's directed by Your Honor. So we would ask you to set bail as requested by the district attorney.
Before we get to the judge, let's talk about this really quick. I saw you smiling over there, Jacob. I would just say off the bat, just my 2 cents is, of course, the defense is gonna, go with the prosecutor and say, yeah, judge, we agree with the prosecutor. We think $50,000 cash, $250,000 bond, and we think that's great. Let's do that. Before we get into the judge thing, now, Jacob, you were a Brooklyn district attorney for over 10 years, over a decade. So you're very familiar.
Significantly over a decade, yeah.
Right. So, and now you're a criminal defensive attorney. So you're pretty familiar, and you do felony cases, criminal, misdemeanors. You're pretty familiar with what's the norm in New York State. This is happening in New York State, where we are. What is the norm? What is, scratch that. What do you think about the prosecutor's proposal for bail on a murder to depraved, where he's charging him on a murder to depraved, wicked, evil, and inhumane charge?
Yeah. So I'll start with this. I probably have started as a prosecutor a lot of bail arguments with, these are very serious charges, or due to the very serious nature of these charges. And when you're dealing with these are serious charges, we're asking for $50,000, usually you're thinking of a robbery or, gun possession, something like that, right? When you're talking about a murder, normally the bail request by the prosecutor is usually either remand, which means to be held without bail, or significantly higher. And I'll caveat this, that a depraved indifference murder is often treated slightly differently for bail purposes because, regardless of what the words are used, I've seen bail on depraved indifference murders, but rarely do I see, bail in general on a murder, but occasionally on a depraved. But when I see it, it's not $50,000. I mean, that is a very low bail amount for the prosecutor to request. And more than that, if I had to be honest, it was such a lackluster bail argument. The defense lawyer actually did a good job getting into how the defendant had known about the serious likelihood of charges for a while and didn't flee, voluntarily surrendered the passport, has turned himself in. Those are all points that New York State bail law requires a judge to consider. The prosecutor didn't really get into any of the meat of it, didn't get into why he's a flight risk. That, I think that while I understand why the prosecutor would, want to, I don't want to say toe the line, but I understand why the prosecutor want to keep this short and brief. I don't think that was a very full-hearted bail argument, in my opinion.
Well, I mean, Jacob, you really don't need a full-hearted bail argument when you're asking for $50,000 for bail, right?
You know what? That is true. But especially when you take the number, and think about the number. He said partially secured bond, which means 10%. That means $5,000 down. Right.
On a $250,000 bond, so that'd be $25,000, right?
Or did he say 250?
The bond's 250, cash is 50. That's what he requested.
What did he say for partially secured? He said 250.
I believe that was for the bond.
All right, so I may have misheard him. But either way, we're talking about, on a $250,000 case, we're talking about only 10% of that. So, right. This is really not a significant bail amount, especially for somebody who's employed. Looking by his age, he's a corrections officer, is probably making six figures. I definitely don't think that's a significant bail amount in the case.
I've been seeing in the comments that there was an attorney in the comments earlier, or at least alleged attorney, and they said, they've never seen, a bail set when there's some sort of evidence. So how does the evidence play into it? Again, I think this goes back to your what you pointed out, that they didn't make a great legal argument on the prosecution side for a high bail amount because they weren't requesting one. But wouldn't factors such as the evidence, the video that the whole world has seen of their depraved indifference, viciously shoving things down Robert Brooks' throat, choking him, we can get into what his injuries were later, bruised internal organs, he choked on his own blood. But why is it that they wouldn't ask for why does that shock you that they didn't ask for a remand in this case, given the circumstances and the evidence that's so strong? And wouldn't that be something a judge should
where do you want me to
consider
start? Because
when determining bail?
Do you want to address the attorney's comment?
Yeah, and then the judge will get to that.
So, first of all, I mean, I would hope any case where someone's charged with the murder, there's evidence, right? A couple of things here that I think are important. On a regular case that's just brought in as an arrest without an ex indictment, you don't really know exactly if there's significant evidence. I mean, you think there's evidence, but you don't really know. Here, a grand jury had a chance to look at the evidence, so there's already been a grand jury indictment. So I think already, in terms of evidence, something was presented. Now, do we know that there's a video? Of course we all know there's a video. But the video is not before this judge, right? It hasn't been put into as an exhibit in the arraignment. So the judge really shouldn't be considering it too much, right? And frankly, without the prosecutor saying anything about it, the only concept that the judge should have about the evidence, because it wasn't put on the record at all, anything about evidence, if the judge is being impartial based on the application in front of him, is that already a grand jury indicted, and they indicted for conduct that is evil, right? So, I guess coming full circle, yeah, I mean, pretty much it. I think that a judge can look at a case and say, you know what, there's a grand jury is already indicted. The problem is the prosecutor didn't say anything about, judge, there's video. So I don't actually think the judge should consider the evidence at all based on that
Right.
application. If the
Right.
prosecutor said, Judge, there's a video of all this happening, then you could say, well, look, you're a high flight risk because there's strong evidence against you, right? But none of that was put before the court. I mean, yes, we all know it, but a judge really shouldn't just say, well, I watched it on CNN, so I know what happened, right? That's really not a judge's job. But look, a murder two is a murder two, and a grand jury indicted for essentially evil conduct. So I think the judge can consider that level of condemnation and saying, look, you're not charged with a crime neg homicide, right? Because he didn't run, right? But he didn't know what he'd get charged with. I'm sure he was hoping for something like a reckless or a crime neg homicide. Especially in New York, where I think there's a reluctance in some regard to charge law enforcement. I wouldn't say that was the most compelling argument. I think, in general, if a judge knows that there's, such clear video and it's on the record, yes, they should definitely consider that, because again, the more evidence there is, the more likely you'll get convicted. Therefore, the more incentive you have to flee, because the purpose of bail in New York is only to ensure your return to court. It is not to protect the public or anything like that. The judge has to determine if you're a flight risk, and that's it. So, again, if you could beat a case, which, who knows? But if you could beat a case, then you're less likely to flee, because who wants to be a fugitive if you can come to court and win?
Right. I mean, makes sense. Let's see what the judge ends up doing. So again, the prosecution asked for $50,000 cash, $250 bond.
All right, the court has considered the statutory factors, and I do take particular note of the reality that if the defendant were convicted of the top count contained in this indictment, he faces a sentence of as much as 25 years to life in state prison. Accordingly, bail is set in the following amounts. That is $100,000 cash, $250,000 insurance company bail bond, or $1 million partially secured surety bond with a minimum 10% deposit. Do I understand correctly, Mr. Cifranco, you have a bondsman available?
I do, Your Honor. I have Mr. Bernard.
So he bonded out in court. So let's get to that. Let's just break this down quickly. So the judge set it at $100,000 cash, $250 bond, and then $1 million. What was that? Because I've never heard of that. I've only heard of cash bond, a cash bail, and then a bond.
Sure. First of all, it's funny how the judge started with, you're facing basically up to 25 to life in prison, which is kind of what I was saying, is that, this charge itself is serious, right? So the judge is taking it more seriously in some ways than the prosecutor, but not much more seriously.
Right.
He's setting, he basically doubled the bail request. So what are the three different things? New York State, by law now, there's bail reform in 2019, requires three different options for bail. And the three most common options for bail are bail bond, which means that a bondsman, you pay them whatever amount of money and then they keep some of it at the end, right? But they pay your bail. Cash bail, which is you pay the full thing. Or what's called partially secured bond, where you pay 10% of the bail set. So if the judge is setting $1 million partially secured bond, then you have to come up with $100,000, and then you can get out. And then if you don't show up to court, then you owe the remaining $900,000. And if you do show up to court, then you'll get the money back, once the case is over, one way or another. So that's sort of the three distinctions. New York does require three different types of bail set.
Okay. Yeah, I didn't know that. So that's definitely interesting to know. But for the $250,000 bond, he has, as you'll see here in a minute, he has a bondsman. There's a bondsman that was there. It was somebody had put it in the chat a couple times, put it in the chat again. But there was a bondsman there who bonded out all of the, well, not all of them, a majority of the correctional officers, the same bond guy. So that would be 10%. That's done really at the bondsman level, right?
Right.
They work out their own deal.
And right. And remember, the bondsman is going to keep some of it. So, even if, you pay them like whatever percentage you pay them, they're keeping about 10%. So you don't get the money back. Right. And right.
You have to put up your house, some sort of collateral.
Right. And it's actually the whole reason for partially secured bond, where you just pay the court 10%, is so that and they have to check your tax returns to make sure you can afford the full, million or whatever. The whole purpose of that was kind of to avoid people having to lose money on the bail bondsman. So that's why, we have that law in New York. But I still, look, I still
But it kind of doesn't make any sense because you have $100,000 cash, $100,000 cash bail, and then you have $1 million with 10% required.
Yeah,
That's $100,000 anyway.
It makes absolutely no sense to set, that. I've seen a lot of judges do it that way. I think
It's kind
in
of
a
just
way,
like pay the cash
in a
bond.
way, the way I would look at it when a judge does that is that a judge is saying, look, I think the bail here should be $100,000. And even though I, by law, have to give you this option of a partially secured bond, I'm going to set the numbers so high that it still comes out to $100,000.
But we can agree. I think we can agree because, let me know in the chat what you guys' thoughts on all this, and then, we'll bring that up. But I think we can agree that $100,000, which is double what the prosecution was asking for, the special prosecutor, it's pretty low for murder too, right?
Yeah.
Like the judge said, they're facing the rest of their life potentially behind bars in the New York State prison system, the same prison system they worked in. And it's I would think that it's very likely on the evidence that I've seen. I don't even know what other evidence they might have. There are people who have taken plea deals already with the special prosecutor, and who knows what they told them, what information, what evidence that they gave them. So again, I think that somebody who is cornered, right? We're all human, right? We all have, flight or fight. And, if you're facing that much time and it's not looking good for you, I think, you are pretty much a flight risk at that point.
Here is available to post that bond at your honor sheet.
So here he just gets the, let's get through this. This is the bondsman here.
It's not uncommon for somebody who knows they're getting themselves, surrendered on a very high level charge to have bail bonds been already ready to go, right? Because why wouldn't you,
Right. And this is Oneida County is not a huge county by any stretch of the imagination. So this guy is probably, whoever he is probably somebody who does, like, he's a very well-known bond person in the area, probably.
But by the way, Sean, as I'm watching this, it just hit me. I am so glad that they recognized your role as a press member and let you sit right up front with every other press member. Yeah, we've had so much argument about this.
I know it was great because at the end of the day, I got there really early. It was just me and a couple other press, and then so much other press came later. But they had like a sign up sheet where you just signed your name, and I put my company, Long Island Audit Inc. I put my name, that I was covering it. They let us into the courtroom first in the jury box. I got one of the closest seats to the defendants, and it was actually pretty cool. It was a good experience. I conducted myself professionally, so hopefully I get to do that again because that was actually pretty cool. And New York, I've tried to get, as Jacob, I've tried to get my court proceedings recorded many, many times, right. And just
they always say no. They always say no.
They always say no. They just say no. And this judge didn't say no because, I guess, how do you say no to something like this?
I think the problem is if you say yes to all the other press and you say no to you, then it seems particularly exclusionary. Whereas if you just say no, right, we're not allowing filming.
I will just say that a lieutenant for the New York State court officers came up to me as I was walking in. And he says, "I know who you are, Mr. Reyes." And I was like, "Oh, that's great." And then he says, "We're giving you a chance to go into the jury box with other press." And he's like, "Let's just relax today," or something. Something to that effect. I'm paraphrasing. But I said, "Well, do you watch my videos, Lieutenant?" He said, "Yeah, I watch them all the time." And I was like, "Well, then Lieutenant, that I'd never conduct myself in a way that's unbecoming unless somebody else does right. something." But
and this isn't that, right?
Right, this isn't that. I was just there. Exactly. Right, it wasn't that.
Your number one obligation is under this bond.
Yes.
What is that?
On court.
Exactly, return to court. Some things I want to make sure you understand. First, you do have a right to be present at all stages of proceedings in your case. But if for some reason you did not come back to court as required, then a warrant would be issued for your arrest. The bail that you're posting by way of this bond, that would be forfeited and lost. You would then face a new felony charge, and that's known as bail jumping. Your case could then proceed in your absence. That means you could be tried in your absence and, if convicted, sentenced in your absence as well. You understand?
Let's talk about bail jumping. Felony, if you're charged with a felony, correct?
I'm sorry.
Bail jumping. He had said that if you do not, the judge had told him that if you do not show for court, you will be charged with bail jumping, which is another felony.
Yeah, it would be. It's not a high level felony, but yes. He also gave him something that's called Parker warnings, which basically is telling him, look, even if you don't show up to court, the case will proceed without you, and you could be convicted without you.
Right, which obviously is not.
No, and I've seen that happen, by the way, where somebody shows up, they get arrested on a warrant after they missed the trial. They have no idea what happened. They don't even know they got convicted, some of them. And then they're sitting there thinking that, oh, now I'll have my day in court. And just like, all right, you're sentenced to 15 years. It's like, what? Well, bro,
Oh my God.
you skipped the trial. So,
Wow.
Yeah, that's got to be a shocker,
Yeah. I mean, not really when you sign a Parker warrant,
Right. And on top of that, you've got a bail jumping indictment. So
right. We got to deal with that. We got to deal with that now, too.
time with that, right.
Yeah. So he basically tells me to come back to court. The guy leaves. So this one was a little bit different. Again, we're not going to go through everything, but I just wanted to show people the differences in
That's your name,
charges.
sir, Michael Fisher?
Yes, sir.
How old are you, Mr. Fisher?
54.
So Jacob, just for your reference, this is a public defender here.
County returned an indictment against you. You are charged with one count of the felony offense of manslaughter in the second degree. On this charge, you're entitled to the assistance of counsel at this and all stages of proceedings. If you cannot afford an attorney, one will be provided to you at no cost to you. Ms. Hartwell here is with the Public Defender's Office. If you qualify and you like, I can assign her to represent you. Is that your wish? He qualifies.
He does, Your Honor. Preliminary qualifies for public defender services.
All right.
I just want to say to everybody, a lot of people in the video, I saw the comments on the video that I posted earlier where I posted this entire thing uncut. A lot of people were saying, like, how does he apply? I mean, I just, my mind is, how does he qualify for a public defender is that, he no longer has a job. Well, actually,
Yeah.
I mean, he no longer has any income, whether he's suspended without pay or whatever until, they go through the process. One of the individuals, Anthony Farina, he had resigned so that way he was able to keep his pension, because I believe when I looked into briefly New York state law that if you resign and you get to keep your pension even if after you're convicted of crimes. But I doubt he'll be able to keep that pension when he gets sued. So
Mr. Fisher, I'm assigning Ms. Hartwell today so you understand. Conditionally, that is that you're going to ultimately, after they get a further review of your finances, properly qualify for assignment of counsel, and then I'm going to have to look into whether or not a conflict exists and they need to assign you counsel. You understand that?
And that makes
You can
sense.
stand in for Arraignment.
If you're saying, look, I make $0 and I don't have the money to afford it, the court is not going to automatically say, screw yourself, get your own lawyer. They're going to say, look, you've got a lawyer assigned to you conditionally, right? Because you have a right to a lawyer. We're going to sign this, but you now have to provide more evidence that you truly need one, right? So it is kind of the right way to do it.
Yes.
Very good. We'll proceed with the arraignment. Mr. Fitzpatrick, you may arraign.
Thank you, Your Honor. Mr. Fisher, in indictment 2025-35, you have been charged by an Oneida County grand jury with a single crime of manslaughter in the second degree. And counsel, I'd ask if you waive a formal reading of the indictment.
I do.
Your Honor.
So I wanted to when I was editing this video, I wanted to bring this up to you. So waiving the formal reading of indictment, could the defendant, so does this defendant, I would assume they're asking to waive because does the defendant have a right to have it read out in open court?
You do, but any lawyer who does not waive that right is going to have, frankly, their ass kicked by everybody else in that courtroom, including the lawyers, because essentially, right, you're given a physical copy of the indictment. You have a right for it to be read in public in court, but nobody does it because you don't only have to read the indictment. You have to read all these other things, like as a preface to it, that honestly, I've only seen it done one time. And everybody in that courtroom is like, oh, shut up, right? Because you don't need it read, right? You have it, literally, you have a copy of it. So there's no reason to have it read in public.
And these indictments can be pretty long, right? You'd probably be there for a while.
You could be there for a long while. I mean, we're talking about sometimes, 45 minutes to an hour on something that's in your hand. So honestly, I'd say 99.9% of the time, you waive the reading, but you don't waive the rights thereunder, right? Because the reading comes with certain rights.
This time I'm going to
Okay.
hand counsel a copy of the redacted indictment, redacted only with one name being removed, along with our standard pretrial notices, along with a disc containing statements allegedly made by Mr. Fisher, and I'd ask you to acknowledge receipt of those items.
I am in receipt, Your Honor.
And they have to give over the statement within 15 days, just like they do the IDs. So that's
Okay. So it
what they're
makes
doing.
sense why they give it to them. And, obviously that looks like this guy talked to somebody, whether if it's law enforcement or I would assume law enforcement. He said
On video.
something. Yeah, he did something to somebody on video or audio, right? He said something to somebody, and not very smart, but I mean,
Enter a plea.
Not guilty, please.
A not guilty plea is entered on the defendant's behalf. This matter will be adjourned to March 31st at 9:30 a.m. for a pretrial conference and setting a motion schedule.
just very quickly, I saw a comment that I want to address. So the body camera footage, even though they didn't turn it on, the body camera footage, Axon has this feature where it will record the previous X amount of time and store it to the cloud. So even though they didn't turn it on, it was just in standby mode. It was technically still recording, and that's how they got the
Maybe I
recording.
missed it. But was there bail already on this? Was there a request? ROR? What was
Not
it?
yet.
Okay.
So this is manslaughter.
Usually
this is
they-
manslaughter.
Right. Usually they do the bail, then they set a date.
You want to be heard on the topic of bail?
Yes, Your Honor. I would ask on behalf of the people, bail be set in the amount of $25,000 cash or $100,000 bond. And I'd also ask, as with previous
You hear people in the audience here laughing.
arraigned defendants, that Mr. Fisher surrender his passport to counsel, and she advised the court and the special prosecutor of same.
Is there a passport to surrender?
Do you have a passport? No, he does not, Your Honor.
So I think it's interesting, Jacob. So for manslaughter, this is a manslaughter charge. He's asking for $25,000 cash, $100,000 bond, but yet he asked for $50,000. I just want to make sure everybody understands he asked for $50,000 on a murder 2 charge. It doesn't make sense to I don't know. I'm not understanding what you're the former prosecutor, you're the former district attorney. Make it make sense.
Manslaughter is significantly less serious of a charge than murder. Manslaughter in the second degree specifically is a non-violent felony. So the sentencing is significantly lower, right? But 25 grand still seems sort of low on a man 2. It still seems sort of low. But if you're asking for 25, I mean, it's not unreasonable to ask for 25 on a man 2 because you're talking about reckless behavior, no intent, not a violent felony under New York law. It's not a stretch. In fact, it wasn't long ago that you couldn't even get bail on a man 2 because New York State repealed bail on a man 2, and then they brought it back because people were like, you can kill somebody and not get bail. It was crazy. But when you compare the level of culpability in a man 2 to a murder 2, and you're just saying, okay, well, 25 to 50, that does not add up. You're 100% right. It's not a 1-to-1.
Just seems very strange. And again, the undertones of all this is that they are New York State employees, right? They are correctional officers, and whether we, want to see it or not, government employees, they get certain perks for being government employees. I feel like they are getting special treatment by the prosecutor in this case because they're correctional officers. That's just my opinion.
Ms. Hartwell, your thoughts on bail?
Your Honor, with regard to bail, again, I would ask the court to consider reasonable bail in this matter. I do see that Mr. Fisher is not charged with 2 counts, but only 1 count. And he is a lifelong resident of the state of New York, and he is not a flight risk. As I just indicated, he does not have a passport, and I can assure that he will not be a flight risk, and I ask the court to consider bail slightly lower than what's been recommended.
The court's considered the arguments of counsel in noting that the defendant could be sentenced to as much as 5 to 15 years in state prison if convicted after a trial. Bail is set in the following amounts, that is $50,000 cash, $100,000 insurance company bail bond, or $500,000 partially secured surety bond with a minimum 10% deposit. understand correctly, Mr. Bernardo is in a position to post a bond today?
Yes, you are.
All right, I'm going to have your paperwork.
Just want to pause it right there. So the judge again ups the prosecutor's ask for bail, doubles it again. The prosecutor asked for 25. In this case, he gave him 50 cash. So it seems to me that the judge, while I think he understands more than obviously the prosecutor, the seriousness of these charges, but still, again, very low ask and very low give, right? But
Yeah,
you
I don't
do
think
this
the
for a
bail-
living. You could tell if that's low, it's low.
I don't think it's low. Honestly, what the judge said for a man 2 is not low.
Right.
It's about right for a manslaughter 2. I think the reason why I think the 25K is low is that's what the prosecutor is asking for, right? So a judge setting that much bail on a man 2 is not unreasonable, honestly, right? And I understand that the whole case is egregious, but the charge itself just isn't as serious as a murder 2, not even close. And when they say 5 to 15 years, that's the max range, which means realistically, if you get sentenced to 5 to 15, most people only do 5 on that, right? Some people may do like 7 or 8, but it's nothing like that. So what the judge said, like I said, is reasonable, but usually the prosecutor is going to ask for, 250,000 or something like that. And then the judge is going to set something kind of lower. But if they're going to set something lower, the prosecutor's request was definitely low, in my opinion.
Right, and I think it's low in the judge's opinion. Right, he raised it both. He doubled their ask.
But with the murder 2, the judge the bail set was also low objectively, whereas for this charge,
It was more in line with the charge as
opposed
opposed to the judge setting the $100,000, I believe it was, cash bond on the murder 2 charge.
Right.
Got it.
Performing now bonds for
So that bonded out. Let's get through this.
Relative to that.
Make sure you come back to court, or you're going to get charged with another felony.
This is the matter of the people against Nicholas Gentile, Indictment 25035.
I was right there when they were coming out.
And
Zoomed in
counsel
right on
is
their
Julie
faces.
Nociolo, correct?
That's correct, Your Honor.
You've been retained to represent Nicholas Gentile?
I have.
That's your name, sir, Nicholas Gentile?
Yes, sir.
How
This
old
one's
is Mr.
interesting,
Gentile?
Jacob. Take a look.
36 years old.
Gentile, you're here today because the grand jury of Oneida County returned an indictment against you. You have to be arraigned upon that. Counsel, you may arraign.
Thank you, Your Honor. Mr. Gentile, in indictment 2025-35, an Oneida County grand jury has charged you in the 8th count of said indictment with tampering with physical evidence, violation of section 215.40, subdivision 2 of the penal law. And Ms. Nociolo, I ask if you waive a further reading of the indictment.
I do.
Your Honor, at this time, I'm going to hand counsel a copy of the indictment redacted with one name missing, along with our pretrial notices and demands, etc. I ask if you acknowledge receipt of those items.
I acknowledge receipt, Your Honor.
And enter a plea.
And for plea of not guilty on my client's behalf.
A not guilty plea is entered on the defendant's behalf. The court will adjourn the matter to March 31st at 9:30 a.m. for a pretrial
Yeah,
conference.
that is weird, right? How they
Ceremony.
do that's kind of weird how they do like when they're coming back and then they do the bail.
Motion schedule.
Yeah.
What are the people's thoughts with respect to the defendant's release status?
I believe this is a case where you can't set bail, so I leave any conditions to the court's discretion.
Do you want to be heard on that topic, Ms. Nociolo?
Just briefly, Your Honor, with respect to any conditions, I agree obviously with the people. This is a non-qualifying offense. Mr. Gentile has been a lifelong member of this community, has a wife and 2 kids, has retained me as counsel, and we ask therefore that he be released on his own recognizance.
All right, the court's considered the arguments of counsel and the bail statute being what it is at present. This does constitute a non-qualifying offense such that bail may not be set on this particular charge. Mr. Gentile, that means I'm going to be releasing you on your own recognizance, which effectively means on your promise that you will return to court when required. Do you promise me you'll do so?
Yes, Your Honor.
Understand that if you were to break that promise and not come back to court as directed, then you're subject to having release on your own recognizance revoked, and that means you could then be committed to the jail with or without bail, so I'll be assured you do come to court when required. Do you understand that?
Yes, Your Honor.
I'm going to pass over a document entitled Parker Warning that outlines your obligations in that regard. the record, the defendant has executed the written.
I never had to sign a Parker warning, I don't think.
Well, because we've never. So usually on like low level charges, they only really give you that orally, and they only give it to you like right before trial. But they're not going to like, they're probably not going to worry too much about it in a case it's like a misdemeanor where they'll just quickly do it orally.
Parker warning here in court. Mr. Gentile, keep in touch with your attorney.
This is basically it for that, and then we'll watch something else really quick. But all right, so you want to explain to people as a New York State attorney what a non-qualifying offense is, and when it comes to bail, and how that all plays out, and how that all shakes out, and then also what we talked about off camera, conditions. And I guess we could, extrapolate that, so the judge could have put additional conditions on the other defendants, correct? As far as like an ankle monitor or confinement to the house or something of that nature.
Yeah, could have, but ankle monitors are just not very common in New York in general. I mean, the law allows for it, but it's very uncommon.
Not even on a murder too. Depraved.
I mean, that whole amount of bail is not common, but even on a murder too, if bail is set, it's rare to get an ankle monitor. In my experience, it's just not something people really think about in New York. I mean, I'm not saying it can't be done. I'm not saying it shouldn't be done. It's just
not.
I just don't see it something actually done often. But getting back to it, so not bail qualifying, right? What's going on there? New York State in 2019 changed the bail law to make many nonviolent felonies not bail eligible. And tampering with evidence is a class E nonviolent felony. There is not even mandatory jail on that if you're convicted, if you have no criminal record. So there is no possibility for bail. A prosecutor can't ask for bail. But what they can ask for is conditions like supervised release or something like that.
Okay.
Normally, if there's a victim who's alive, you could ask for an order of protection or something, but not really in a tampering case. So there are conditions that a judge could set. But in a case like this, look, realistically, you would have to be very, very stupid to not show up to court for a tampering case, because it is low enough that the consequences of not coming to court are significantly higher. So it does sort of make sense. I mean, I think that it wouldn't be crazy for the prosecutor to ask for supervised release, but at the same time, I mean, realistically, this is somebody who's a very low risk of not showing up to court because they have a very low level charge.
And again, put it in context with, the softness of all the prosecutors asked the entire time, obviously on the low level case of that classy felony, as you said, with no mandatory jail time, he's not going to be tough on that either. Again, I think the prosecutor was weak the entire time.
I mean, with the felony, I think that's not uncommon. I mean, no matter who it is, I don't think it's very common to have bail requested. Oh, sorry, strong conditions requested. I mean,
right.
Yeah.
So I just wanted to answer this question. Was there an update about the one who didn't turn himself in for this hearing? So yeah, they redacted his name out of the indictment. Apparently he, the prosecutor basically said, Jacob, the special prosecutor basically said at the press conference, like, best case scenario, his attorney, it was a misunderstanding, but basically he was saying like, I don't know, but that's the best case. Apparently he's out of he's doing something that the prosecutor wouldn't say, that he couldn't, he couldn't make it. I mean, it just blows my mind because I'm thinking about this and I'm like, well, they came, Nassau County came across county lines to pick me up on a Friday night on a warrant, on a low-level warrant, and these guys on a trespassing warrant, and these guys are just not. But he's going to be arraigned next week, I believe. So I just wanted to watch like 4 minutes of this thing that the press conference that I was at.
I real quick though, the one thing I can tell you, I don't know if this is really what happened or not. The only time I could really see something like that happening is, again, someone's turning themselves in. That's always a plus. If the attorney's unavailable, like, where I've had myself like going to be out of town for the week and they want him to turn himself in on a case, and I might ask for a little bit of time, but I feel I don't know what the exact charge is on that person, But if it's like anything other than a
I think
tampering
it's murder.
evidence, it is. Yeah, if I'm a prosecutor, I might say, look, I'm trying to work with you here, but send somebody else or whatever.
Right.
I don't know. I'd love to hear,
And especially
why.
because he had something else to do. Again, he wouldn't go into specifics
Yeah,
of what he was doing, but he apparently was doing something to defend it.
Unless it's like a medical thing where you have like a pre-scheduled, procedure. I can't think of a lot of reasons why it will go down that way, but you never know. Without knowing what happened, I'll keep an open mind, I guess.
And I just want to make it clear to everybody that's watching right now. Thank you guys for being here. Hit that like button and share this video. But this prosecutor, he's the Onondaga. He's not the Oneida County. This is happening in Oneida. He's the Onondaga County District Attorney. He is the same district attorney that refused to press any additional charges on Sandra, the district attorney from Rochester, who pulled away from the traffic stop, went home, did all that stuff, acted weird to the cop. He refused. That's a little side note, but let's take a look at his press conference.
And finally, the third tier, those who were to a lesser extent aware of what was happening to Robert, or should have been aware of what was happening to him, and did nothing. The most important question that we faced, and which I think will be the centerpiece of the trial, whenever that is, will be, what did Robert die from? The latter question has been answered to my satisfaction and to the satisfaction of the grand jury by the Onondaga County Assistant Medical Examiner, Katya Merkulova. Robert died of massive beating to his body, both externally and internally. Several of his internal organs were bruised. His hyoid bone was fractured. His thyroid cartilage was ripped. He also died as a result of repeated restrictions to his airways, causing severe brain damage. And finally, he died by choking on his own blood. Our investigation revealed that in addition to the tape beating, which you probably have already seen, Robert was beaten on 2 prior occasions between 9/07 and the time of his death, within minutes of his arrival at Marcy. Our investigation further revealed that there was no provocation by Robert Brooks that would have precipitated any physical response whatsoever, never mind the physical response that was inflicted upon him. I think any sentient human being looking at the tapes naturally comes to the conclusion that he must have said something, he must have spit at the officers, he must have resisted in some way, and the fact of the matter is he did absolutely nothing. The first beating took place in what is referred to as the Arsenal section of Marcy. It's the first enclosed structure that Robert entered after disembarking the bus from Mohawk. The second beating took place outside as Robert was being escorted to the infirmary. And by the way, he was being escorted to the infirmary because that is standard procedure when an inmate arrives at Marcy. And the third and final and fatal beating took place in the emergency room of the infirmary, which I said many of you have seen on tape. Indicted for murder in the second degree under a theory that they acted with depraved indifference to human life and caused Robert's death are former Marcy Corrections officers Anthony Farina, Nicholas Anzalone, David Kingsley, Christopher Walworth, and Matthew Gallagher. They face as potential punishment life in prison. Indicted for manslaughter in the second degree for recklessly causing Robert's death by essentially doing nothing are Michael Mashaw.
Okay, stop there. So by doing nothing, we know that there was that, his theory of the manslaughter is that he did nothing, right? We were talking about this off camera before we came on, right? What is it that, why is it that, I think a lot of people want to know, is that there's 17 people that were in or around the area that could have done something, should have known that was going on, should have stopped it, because the Supreme Court has ruled, I believe it was recently, I don't know the exact year, that law enforcement officers have no obligation, no duty to protect citizens. But law enforcement does have an obligation and a duty to protect people in their custody, like Robert Brooks. So this individual was charged with manslaughter, Jacob, in the special prosecutor's words, for failing to act. What do you think made his failure to act different than anybody else's of the 17 other correctional officers for failing to act?
I don't know. I don't really know just from the video who that guy is in the video.
Right.
I don't know what the witnesses said to make his failure to act more specific. I don't know if he was a supervisor who maybe had a higher duty than the rest of them. I don't know. But I will say this: when he started off by talking about some of those injuries, which I think were just hard to listen to,
Right.
that's something I would have expected as part of a real bail argument. I would have expected that. And
Right.
with those kinds of facts, I like hearing the details of what he's saying, that there was no reason, right? It's not like there was some emotional disturbance, the guy spit in their face or something, which again doesn't justify anything. But context kind of matters in the legal system. Hearing all that, it just makes the bail request for the murder 2 sound even more inappropriate.
Right. Again, $50,000.
Yeah.
I just $50,000 for a murder 2 depraved indifference, where they broke his, thyroid, cartilage, everything that he listed, bruised internal organs, just depraved, evil, wicked, inhumane in the jury instructions. We
Do
see
you know
here
if
that-
there's any donations from like the court officers union or anything? I have no idea. I'm just asking if you
for what?
from like a court officers like a political.
I don't
campaign.
know. It's something I want to look into too. I don't know if like the union, so they have like a
Right,
union that's going to provide them with attorneys, or I don't think so as of yet, only because some of them had public defenders and some of them had private attorneys. So if the union was paying for all of their attorney, I would assume they all have, all have an attorney, not need a public defender. So let's just finish this.
Michael Fisher and David Walters. They are facing a potential 15 years in state prison. And finally, indicted for tampering with evidence is Nicholas Gentile, a Class E felony punishable by 4 years in state prison. One additional defendant has been indicted for murder in the second degree, and he was unavailable to surrender himself. We do not believe he's a flight risk. He will be arraigned in the very, very near future. 3 former Marcy Correction officers have reached plea agreements with the special prosecutor. I will not reveal their names nor their plea agreements until such time as they appear in court and enter their guilty pleas. At least 2 current or former Marcy employees and at least 1 current or former Mohawk employee are still under investigation, and the grand jury is still sitting and still able to hear evidence. I would advise them to seriously consider cooperating with the special prosecutor. That, of course, is their choice.
Okay, so explain that last part. Well, we kind of answered. Well, they kind of answered our question, or my question anyway. 3 people are cooperating, right?
Mm-hmm.
They've already came to plea deal agreement with the special prosecutor here, Fitzgerald. So that's 3 people. That's why they weren't probably charged with manslaughter or something of that nature.
There's something else I have to point out. We have no idea if the special prosecutor submitted charges against everybody and the grand jury didn't indict them. So I really do have to be clear about that, because this is an indictment. This isn't like a charge that the prosecutor himself presented without an indictment. So it has happened in the past, and I keep an open mind that charges are submitted and the grand jury just doesn't find enough evidence. That also may be why, again, I have no idea why the grand jury is still weighing evidence, right? Because they may be seeking additional evidence against those other people, for all I know.
Gotcha. All right. So I just wanted to really quickly thank you, Freddie Torres, for becoming a member. LTL Media, LA, because of you, I've been following this case from Massachusetts. Such an injustice for Robert Brooks. Thanks for exposing the corruption. Please give it the good work. Thank you so much for that. Appreciate it. It is an injustice. It's absolutely disgusting what happened. It's a hard video to watch. I don't even think I've watched the whole thing, honestly. And to hear it described by the special prosecutor here is just, crazy. But and again, I think Jacob makes a great point that he is explaining this heinous, depraved, inhumane, evil, wicked murder, this brutal beating that took place, and he's asking for $50,000. And again, I don't know why. I'm not in his head. I have no idea why, but my opinion is that it's because they're correctional officers. I'm sure probably most of you share my same opinion. DJ Davis, thank you so much. Any final words, Jacob, before we get out of here, man? It was very thank you for taking an hour. I know you charge like 5,000 an hour, so I appreciate that.
Yeah, okay. Man, people got the wrong idea, bro. I wish. But look, I'll say this. I mean, I am interested to see, once the indictment's unsealed and a little more information about what really happened with the grand jury and stuff. Clearly, this was way above the line, but you're not wrong, especially upstate. There is a you're not wrong at all. There's a relationship in these smaller counties between the corrections officers and all the other law enforcement, including the prosecutor's office. So on the one hand, I'm happy that they actually are charging these people. I don't see how they couldn't. But, I think really what's going to come down to is, what are the pleas going to be here, right? Are they going to be offering them low-level pleas, or are they going to actually hold them accountable, right? And at the end of the day, that's really, I think, what's going to matter more than anything for the family of Mr. Brooks, and for the public. I think is not just say, okay, like the bail is one part, but what happens down the road, right? Are we going to end up with man 2 convictions for the murder 2 people, or are they going to actually face real accountability?
Right. So, I think that's a great point that you made. At the end of the day, right, we're focusing on the bail aspect of it now and how absurdly low it is. But, the ultimate goal is for justice for Robert Brooks. That means holding those responsible for his murder accountable. And that's a big part, right, is the special prosecutor. And again, it doesn't leave me with a good feeling that he's going to go all the way on this trial when you're starting off with such a low bail amount. Again, does it correlate? Probably not. But just for me personally, it doesn't give me a good feeling that he's going to, vigorously prosecute this case. I think my prediction is that there is some sort of plea agreement with everybody involved, which again, plea agreements aren't unheard of, right? I mean, they happen every single day in court, right?
Yeah,
that's what majority of what happens in court is people plead guilty to a lesser charge or the same charge with an agreement for time and everything else. So it wouldn't be out of the ordinary. But for this case, in my opinion, for this specific case, I think a plea agreement for the ones that were actively involved, I think that would send a very bad message to the public and the public's trust for law enforcement and holding them accountable. Because at the end of the day, these people, not only did they murder somebody, they had a duty to protect. We talked about this earlier. They technically could be charged federally for violation of rights under color of law. They had an obligation to protect this man. He was in their custody. He was handcuffed behind his back. He was helpless, and they brutally murdered him. And
I don't think a plea automatically is a bad thing, even in this case, right? The question is it a plea that's fair to the people of the state of New York,
right,
who do want accountability in the family? So, if it's a plea to, murder 2, 15 to life or something versus a maximum of 25, that's not unreasonable under the facts of the case. Even a man 1,
10 flat.
10 flat is low.
Right.
Right. But if you're offering, 15 years on a man 1, is that something that I would say is out of the ordinary on a depraved case? No. Right. Because remember, they can go to trial. And even though we all know what this is, these are upstate counties. It could be hard to win
juries.
Yeah. That's what I meant. Yeah. It could be hard to win a murder 2, right? Under depraved, even though we all have like our own common sense and morality.
Right.
But
some of these people don't. Some people in the world don't.
Right. So, we'll see what happens. But not every plea is a bad plea for the government. And that's, I hope that if there is a plea offer here, that it's fair to the family of Brooks.
If it's fair to the family, that's really what matters most to me.
Right.
If it's fair to the family, people will still waiting for the Academy for Ordered Academy. Jacob Smith, thank you. I like your name, Jacob. I don't think we ever done a live that was an hour long before. But it kind of felt, this is kind of like, now that we're at the end, it's kind of like, all right, I'm laying back a little bit, I'm getting a little relaxed, Jacob and I should do a podcast or something, we gotta start doing something where we talk about
I have
legal
one.
issues and things like that, because it's always, I love to learn from Jacob. He's a great teacher. He's a good friend, and I've learned a lot about the law from him and about life in general, honestly. So it's been good. But if you guys have any questions, let me know really quick, and then I'm going to be getting out of here in like a minute. So let me know now.
Oh, we're taking
Let's
questions.
see here. Thanks. Your beard's always on point. I appreciate that. Thank you so much. I was at Marcy Correctional Facility, got released in 2004. Marcy was not like that. Them officers had to come from Midstate and Mohawk. Both facilities were known for assaulting inmates. I mean,
It's been a long
what,
time.
Jacob? And I think it's a good point, is that when you watch the video and you see the surrounding faces of people who are in the hallway, the male nurse who was smiling, as upon walking up on this scene, right? This horrific scene, to anybody else would be horrific. It just leads me to believe that this is a culture that has, perpetrated in all of the docks facilities, most likely, because especially in Marcy, because if you're a nurse, you go and you walk in and you see somebody getting viciously beaten, and you're like, oh, you just smile, like this wicked smile. Even if you're like a racist, horrible person, you walk in on that for the first time, you're going to be taken aback by it.
Yeah.
Whether you approve of it or not, you're just going to be like, oh, this is something I haven't seen before, right? This is new. What are we doing here?
Right.
When you walk in and it's a comfortable situation, it leads me to believe that this is something that is routine, that always happens. I'm going to be bringing on a correctional officer anonymously, that he's going to be telling me all the inside goodies. Apparently, this is like some sort of beatdown squad, and this is called George Floyding somebody. Why public defenders? Why the public defenders? Do they forget others were being charged?
Plus that commenter, was last in that facility 20 years ago,
Right.
And cultures change, things change.
Right.
He
was basically saying Marcy wasn't like where they beat you down; it was the other ones. So
yeah, and that may well have been true, but it doesn't look like that's true now.
Right. No, it doesn't look like that at all. I actually went to the Anthony Farina's. I know I told you about it. I went there to ask him some questions, and his son threatened me with violence. And there was his adult son, I should say, threatened me with violence. And he had mentioned something about, oh, what happened? You don't know what happened at Mohawk. That's where Brooks was before Marcy. And it just seems so weird to me. It's like, I understand it's a family member probably just grasping for anything to try and, not realize that your dad's a depraved, inhumane, evil murderer. I understand that, but I mean, Marcy happened after Mohawk, just so people understand.
What really gets you, though, I gotta tell you, what gets me more than anything out of this whole thing, I mean, obviously what they did was horrible. Sean, the fact that all these corrections officers are on strike, the timing is not a coincidence, right? None of these people truly have a problem with what happened if you're striking, given what we all saw in that video. I mean, this is not the timing of this, is either crazy tone deaf, right? And if you don't know, by the way, if you're watching from somewhere not in New York, the governor is sending in the National Guard to become corrections officers because most of them are on strike, and they're not even allowed to strike legally. So I've got to tell you, it hits me as very tone deaf or very callous in terms of a culture where you could see a video like that and say, you know what, I'm going to strike now, pretty much as soon as this indictment's released.
Literally the same exact week that the indictments were released, the entirety of a lot of correctional officers went out on strike all across the state, which again, Jacob had mentioned, it is illegal to do in New York State to do that, and they did it anyway, and it's for their safety and their rights and working long shifts. And I think that's a great point, Jacob, that's extremely either tone deaf or callous and not caring about, because the same week, it just seems very coincidental that they would be going on strikes the same week that these officers are getting indicted. To me, it looks like you're really doing it about that. But you're like making up some other reason that maybe are valid reasons, but this pushed you to the edge of
Yeah, well,
wanting to
last I
say,
checked, there wasn't a correction officer beaten to death in the last.
right, exactly. I mean, I haven't seen any. I haven't heard of a correctional officer
No, I
being
haven't.
beaten to death by a bunch of inmates. So I mean, it again, do they have a shitty job? Well, I think they do. I know they do. But it's just it's a job and you have to do it or don't. But quit. You don't get the benefits of the money and the overtime and everything else, and then get to complain about it. And the free health insurance. Yes, I've shared that video on my channel, but I'm gonna see if I'll share the whole thing where he went over there and some auditor went over to while they were protesting, said, "Are you protesting for justice for Robert Brooks?" And the person was like, "No." I just like that though. No, like how dare I wouldn't be out here illegally protesting for
They
that.
don't see him as worthy.
But again, tone
human
deaf,
dignity.
right? Tone deaf.
Yeah.
It's absolutely insane. How many beatdown squad was? How many people did this beatdown squad take before it all went public? Listen, and the sad truth is, like, this video footage wouldn't exist. I don't know how they eventually came across it. Like, how would they know to save to go look for this? I have no idea. But at the end of the day, they found the video footage, and they should really have cameras everywhere in correctional facilities and that record to a cloud, so that way it holds everybody accountable. Because obviously this is a problem. I think this is a huge, major problem in New York State that needs to spur some sort of legislation to make these events happen less.
You just reminded me of saying something. In terms of intent,
Yeah.
I think the fact they didn't have their body cameras on in what clearly was a very confrontational encounter tells me that they knew they didn't want to be filmed right from the get-go,
Right.
which is probably something that is going to be argued later down the road in terms of what their mindset was, what they were thinking. Right.
I mean, it's a good point that their intent. It's pretty clear, I think, to anybody who has any sort of common sense and it is unbiased and is critical thinking what took place that day. Again, but Jacob makes a good point. He is the attorney here, and he's making a good point when he says this is a county that's in upstate New York. It's a rural county in the middle of the state. That's where the jury pool is going to come from. And as much as you watching think, or maybe you don't, maybe you're one of the people in those counties, but one of the people that would vote this way, that would find not guilty in this sort of situation, they exist. And, that's something that the prosecutor has to contend with and take in as a reality, that these people exist and, they could end up walking.
Right.
Hopefully that's not the case here. Sean is Homeland Security guy, wanted to go hands on to still have a job. Dangerous guy. Yeah, of course. They all do. Listen, anybody who's ever done anything dangerous or wrong to me still has a job, unfortunately. Except for the guy who said 20 years ago he would have killed me and my teeth would have been missing. He resigned. He retired, actually. So, all right, guys. Well, we're going to be getting out of here. Thank you so much, Jacob, for joining me. I'm super tired, ready to go to sleep, but I appreciate you, Jacob.
Always
Thank
a
you
pleasure.
so much.
Really.
Thanks, man. Appreciate you. All right, guys. So Jacob's getting out of here. I'm getting out of here. Let me see here. I appreciate all of you guys. We wanted to break down this case tonight. I just put out the video this morning, so I just wanted to, I'm a little tired, but I wanted to break this down today for you guys. So stay tuned to the channel. Got some billboard truck videos coming up from some protests and more updates on the $75,000. What's crazy that I didn't mention? I'm being charged for $75,000 in code violations as far as fines, and these murder 2 correctional officers being charged with murder 2 depraved indifference are getting $50,000 bonds. Like, I don't know. Just doesn't make sense. But anyways, guys, as always, stay safe. God bless. I'll see you in the next one. Long Island Audit. Peace.